The broadcast is now starting. All attendees are in listen-only mode.
All right, Francesca. Francesca, I think we're ready to start. Francesca, I think you may be muted. Hi everyone, this is Stephanie Nishio with the California Association of Food Banks. Hang on one second while we figure out this audio thing.
On sponsorship in CalFresh. I'm Francesca Casa from the San Francisco Immigrant Food Bank. Please note that the webinar is being recorded and it will be posted on the CAFB website by the end of the week. You can submit questions at any time through the question box. We will be monitoring your questions the whole time. Just a heads up, because we anticipate there might be a few more questions than usual on this topic, we will plan to accommodate questions for an extra 15 minutes if necessary. The webinar will end no later than 2:45. If you have to leave early, you can always follow up by watching the recording once it's available. So without further ado, we will have Tanya Broder be speaking. She is a senior attorney at the National Immigration Law Center based in Oakland, where she's been working since 1996.
Thanks so much, Francesca, and hi everybody. If you see your screen, we have a PowerPoint that I'm going to go through, and you'll get copies of it, as far as I understand. Okay, we're going to talk about issues affecting access to CalFresh for sponsored immigrants. First barrier that immigrants face are the immigrant eligibility rules. Not all immigrants are eligible for food assistance in California. Even if they are eligible, immigrants have concerns about their privacy, confidentiality, and verification requirements for themselves and for their family members. We're going to go over that a little bit today. People also have concerns about public charge, and the idea is, will using nutrition assistance affect my ability to become a lawful permanent resident or a citizen, or otherwise affect my immigration status? We're going to go over those rules today. And concerns about their sponsors. What effect if an immigrant came to the U.S. through a family member who sponsored them to come here? Will using CalFresh affect the sponsors, and will the sponsors' income be counted when they apply for CalFresh? And that's the main set of questions we'll answer today. Finally, there are other questions that I won't get into, but Cindy may get into, which have to do with barriers related to linguistic and cultural competence, logistical barriers, and the climate, whether it feels safe and welcoming to go in and get nutrition assistance. These are all things that need to be addressed in order for families to get the CalFresh for which they are eligible. So the first set of things to go over are questions about immigration status and Social Security numbers. The federal government has directed all agencies across the country administering the SNAP program, or CalFresh in California, not to ask unnecessary questions about immigration status or Social Security numbers. Those questions are only required of people who are actually seeking to receive the benefits themselves. So if you're a parent, you're seeking benefits for your child but not for yourself, you don't need to answer questions about your immigration status or your Social Security number. If you are seeking benefits and providing information about your status, that information will be verified with immigration, with the U.S. Citizens and Immigration Services, but it will only be used to determine your eligibility for benefits. People seeking services for their children only or for other family members must provide proof of their income, but they can use alternative methods. They do not, if they are working in the informal economy or they're using a Social Security number that was not issued to them, they don't need to provide that Social Security number. They can provide other means of establishing that they're eligible or what their income is, like a letter from their employer or other or declarations from various people for whom they perform services. So there's a lot of flexibility in how they prove income, and the main goal is to capture the correct information from the family about their income. Public charge. The good news, and again we'll go over the public charge rules, the good news is that using CalFresh is not even considered in a public charge determination, the determination about whether someone is likely to rely on the government in the future. Using CalFresh doesn't count at all. It also doesn't affect applications for citizenship unless an individual has provided false information on the application form. In any case, false information provided on an application form will be considered just a moment, in the good moral character question on the citizenship application. Nevertheless, sometimes a question asked on an immigration form can deter a family. A family who's applying for lawful permanent residence may be asked what kind of benefits they've used. That's not going to count against them, but it sometimes makes people feel concerned. We can work with you all to get the correct information to people so that they don't feel concerned about those questions. As long as they tell the truth, they should be fine. Using CalFresh will not count against them. And similarly, use of various benefits can come up in court when a judge has all kinds of discretion on whether to grant you a special form of relief. And again, it's more, we don't know of any cases where using CalFresh has gotten in the way. It sometimes makes people nervous to even hear the question. Here are the public charge rules. Public charge is a person who has become or is likely to become primarily dependent on the government for subsistence, as demonstrated either by receiving public cash assistance for income maintenance, that's like monthly cash assistance, or if the person is institutionalized for long-term care at government expense. If you are determined likely to become a public charge in the future, it could affect your ability to get your permanent resident status, to enter the U.S. initially, or if you already have your green card, it normally doesn't affect you at all unless you leave the country for more than 6 months and attempt to re-enter. If you do that, you're sometimes treated like a new entrant, and they may look at the public charge question at that stage. What is the public charge test? It's a forward-looking test, and it considers a lot of different factors about the person, your entire circumstances. It looks at your age. Are you old or young? Your health. Are you healthy or not? Or, do you have a disability? That could be considered. What kind of job do you have? What kind of education and skills do you have? What kind of income are you earning or likely to earn in the future? What kind of family are you trying to support in the U.S.? And most importantly, and what we'll talk about today, to overcome the public charge test, that is when you're trying to get your green card, if you're going through a family member or others, family members who own a business or who are petitioning for you, your family member may be asked to sign a contract or affidavit of support promising to support you in the future to help you overcome the public charge grounds of inadmissibility. That affidavit of support is the most important thing in the public charge test for immigrants seeking their green card through their family members. Okay? So when you're looked at for public charge, you know, are you going to be a public charge? All those factors that I just mentioned do count, but lots of things don't matter at all. So if you're using healthcare services, nutrition programs like SNAP or WIC or school meals, housing assistance, childcare, job training, disaster assistance, none of those things factor into the public charge equation. In fact, using some of those services actually helps make you more productive in the future and helps ensure that you can support yourself and your family. So for your purposes, CalFresh is just not even relevant in the public charge equation. Okay? And even for people who have used cash assistance like SSI or TANF, that is CalWorks in California, or general assistance, for a short time or a long time ago, that may not automatically make you a public charge if you can show that in the future you're on your feet. You only used it a little time. You used it a long time ago, and now you've got a job or a job prospect, and you will be fine. You can get over the public charge test, even if you use cash benefits. If you're in long-term care, like a nursing home, that's actually, you're likely to have other barriers like health or income or other factors that make you more likely to become a public charge. So you may not want to try to adjust your status. If you're in long-term care, you may be able to just stay there and be fine without it. Each case is different, so people should consult with an immigration lawyer if they have any questions about public charge. And that's a general rule for all of you. It's the most important thing on all of these immigrant issues is to make sure you're aware of the local immigration resources that are available, so that if anybody who you're working with has questions about immigration, they can actually go and talk to someone about their own case. Going through this quickly since I'm not, there's no back and forth yet, but please feel free to ask questions, and I'll stop for questions in a bit. There is no public charge test for a number of different types of immigrants, including people who fled persecution like refugees or asylees, people granted withholding, a trafficking survivor, a U visa applicant or holder, that is someone who is a survivor of a serious crime who's cooperating with the authorities to prosecute the perpetrators of the crime. They do not have a public charge test. Neither do many other categories of immigrants listed here, including young people in the foster care system who are applying for a green card as special immigrant juveniles, and certain other folks. And as I mentioned earlier, there is no public charge test for green card holders who are applying for citizenship. So no public charge there. The only thing they look at is, did you follow the rules when you received benefits? Were you really a California resident? Did you provide correct information about your income? Things like that. Otherwise, you're good. Using anything, including cash, welfare payments is fine if you are applying for citizenship. Okay. Now to the kind of heart of the presentation, and we wanted to talk about what happens when somebody sponsors someone else to come to the United States. They sign an affidavit of support, a contract by the sponsor to support the immigrant. And there was a traditional affidavit of support that was not enforceable. It was called an I-134. It's still in use by some people, but it's not relevant to the CalFresh program. The one kind of affidavit of support that is relevant is the enforceable affidavit, and I put enforceable in quotes for a reason. It's the I-864 form, and certain immigrants are required to have a sponsor sign that form beginning in 1997. Okay. So that enforceable affidavit, the I-864, is a promise to support the immigrant at about 125% of the federal poverty level, and at least in theory, to reimburse the government for what's called means-tested public benefits used by the immigrant. The sponsored immigrant may be able to enforce the contract against the sponsor, and this comes up sometimes in spousal support or child support cases. They throw in the affidavit, hey, you promised to support me at 125% of poverty, you're not doing it. It comes up sometimes. And at least in theory, it can be used by benefit agencies to go after the sponsor or benefits used by the sponsored immigrant. We'll talk about the extent to which that is or is not happening now. And finally, the Enforceable Affidavit of Support, it triggers certain deeming rules where the sponsor's income is added to the immigrants in determining eligibility for certain programs. And that, again, is what we'll go over in a second. Okay. This special form, the I-864, is required only for immigrants who are getting their green cards through a family-based visa petition. So a family member is petitioning for them, or in a smaller number of cases if they're getting an employment-based visa when a relative owns more than 5% of the business. Some people don't have to file affidavits of support even if they have family members petitioning for them. And that would be a battered spouse or child who's filing a self-petition under the Violence Against Women Act, or certain widows or widowers, or if somebody has credit for 40 quarters of work history in the U.S., and that could either include her own work history in the U.S., or you can add the spouse's work during the marriage, so you total them up together, and if you together have a total of 10 years of work history here, you don't have to file an affidavit of support. And children, or even grown children, can count the credit and for the work that their parents performed before they were 18, even if they're grown now. And people who are actually citizens under the Child Citizenship Act don't need to file an affidavit of support. So the only people who do file them are the family-based, really the family-based visa petition seekers are the ones who tend to have the enforceable affidavit of support. That's the only affidavit of support that's relevant in terms of the sponsor deeming rules in the CalFresh program. Okay? The deeming rules, which is where you count the income of the sponsor, you add it to the sponsored immigrants in seeking of benefits, only apply to people who already have their green card. They've already got their green card. They immigrated through the family-based petition. And again, the income and resources of a sponsor may be added to the immigrants in determining eligibility. There's a formula for that. What the deeming rules do is they render the immigrant over income for the benefit often, even if the immigrant family or the immigrant is receiving nothing from the sponsor. We're going to talk about some very important exceptions to these deeming rules. So again, sponsor deeming only applies to people with I-864 affidavits of support only after they get their green card. It can render the person ineligible or the family ineligible for the benefit, but there's some important exceptions to the deeming rules. Let's look at the CalFresh program, which I've divided into two parts of the program. One is the state-funded program called the California Food Assistance Program, which is called CFAP. So here's the weird thing. A new immigrant comes to the country and you're an adult. Okay, CFAP really serves new immigrants who are adults. They're called qualified immigrants. We're just talking about green card holders now because we're talking about deeming. So you're a green card holder. You come to the country, and for the first 5 years you have your green card, you need to get state-funded benefits, CFAP. You're not eligible for federally funded benefits under SNAP until you've had your green card for 5 years. So you've got a 5-year window where you're only getting state-funded food stamps, which is CFAP. During the first 3 years of that window, your sponsor's income will count, will be added to yours unless you're a domestic violence survivor, you're indigent, or your sponsor is also a member of your household, your food stamp or CFAP household. Okay? We'll go back over this. Once that window ends, you're an adult. CalFresh, you get SNAP or CalFresh after 5 years, but you might face a new barrier. So now you've got CalFresh, but you have deeming again until you become a citizen or you get credit for that 40 quarters of work history in the U.S., unless you're a child, so there's no deeming for children in either program, you're under 18, no deeming. A sponsor is a member of your household, no deeming in those circumstances. You're a domestic violence survivor, no deeming. Or you're indigent. That is, you would go hungry or homeless without CalFresh. What does that mean? Indigence exemption. I know I'm going quickly and not pausing, but I hope you save up your questions and we can go back. Indigence exemption. That is, you would go hungry or homeless without assistance when counting your, and the way they do it is they use an objective test that syncs really well with the food stamp eligibility rules. What they say is, if your actual household income plus any contributions, including in-kind assistance, is less than 130% of the federal poverty level, then without CalFresh, they decided you would go, they being the federal agency, you would go hungry. So you're actually eligible without counting your sponsor's income and without any deeming if your income, including in kind, is less than 130% of the federal poverty level. These indigence determinations are renewable for 12-month periods. And here's the reason why some people don't want to seek it. It really makes almost any sponsored immigrant eligible without deeming. But there's an additional requirement when someone gets an indigence exception that the food stamp agency report the name of the immigrant and the immigrant sponsor to the USCIS, the service side of the Immigration Service, their policy division. Now, we at the National Immigration Law Center are not aware of any consequence of that report. We can't even imagine what the consequence would be. We think they're gathering it for statistical purposes, but just knowing about this, and you can tell me what your experience is, often deters families who feel stuck. They're afraid of it, even though there is no known consequence. So that's a barrier. And because of that barrier, some family members who are sponsored may choose to opt out of the food stamp unit. If they opt out of the food stamp unit, and that's supposed to be done early in the application process, then the other family members can still apply. The member does not need to disclose anything about the sponsor or anything about his or her own status. He or she will be treated as if the person is an ineligible non-citizen, and which means that let's say it's a parent, that person's income is prorated to the other family members who are seeking assistance. So the whole family will receive less, potentially, than they would if they declared indigence and sought benefits for everyone. But at least some family members can seek assistance, and they can avoid this report of name of themselves and the sponsors to USCIS. Okay? And at the end, I'll show you there's a link to an all-county letter that lays out this rule. Okay. The other thing that, and I don't know whether the people, well, I'll keep going. The other thing that people are concerned about is, what if I do use food stamps? Will my sponsor have to pay it back? Now, the sponsors, sometimes called sponsor's liability. In theory, the sponsor signs this contract, and he or she has promised to maintain support until the immigrant either becomes a citizen, earns credit for 40 quarters of work under the rules I mentioned before, leaves the U.S. permanently, or dies. And there's still questions about whether it would be dischargeable in bankruptcy if there is a debt that's created from the Affidavit of Support. And the other thing the sponsor agrees to do is to reimburse the government if the immigrant uses a means-tested public benefit, which is defined at the federal level to include just a few programs, but to include federal SNAP. And states are to determine which programs are included in the definition. So far, California has not designated any program as giving rise to sponsor liability, so we don't have anything there. California, if it does choose to go after sponsors for state-funded programs, it needs to provide notice in advance to the public that it's going to do that, and it cannot collect for benefits that were used prior to giving that notice. So California policy could change in the future, but even if it does, they can't go after you for state benefits used before they make that public notice clear. So, and they also can't go after folks for SNAP that's used by the sponsored immigrant. So if a sponsor is receiving SNAP, they're not liable for SNAP used by sponsored immigrants. Now, those were the rules. They sound a little scary, but in practice, there are a lot of reasons why benefit agencies across the country have chosen not to seek reimbursement from sponsors as a general rule. Many have determined that the cost of doing so outweighs the benefits, that it deters people who really need the benefits. There aren't any penalties for states if they choose not to pursue reimbursement. And importantly, in the SNAP program, a state can't keep a penny of the SNAP that it recovers because it's all federal money. So basically, the Federal Food Stamp Agency has said to the states, you don't have to go and pursue sponsors. We're not going to penalize you if you decide not to. It's up to you. And if you do, though, you have to give all the money back to us. So this is a kind of doesn't inspire states to go running after sponsors and spend money just to return anything they collect to the federal government. I have some hypotheticals, and I don't know if it makes sense first to open up the, well, I'll go through, we've got time. I'll go through some hypotheticals, and then I will ask the other moderators to send me any questions that are coming up in this presentation. So real quick, Veronika and Hana. Veronika has her green card. She's a lawful permanent resident, and she's applying for U.S. citizenship. She and her daughter Hana have received CalFresh for 3 years. Do you think it'll affect your naturalization application? And actually, what would be great is if you type in your answers, and one of the other moderators can maybe tell me what answers she's hearing. So do folks on the phone who can type into their question box or chat box think that using CalFresh for 3 years will affect a naturalization application, an application for citizenship? Can another moderator read me any responses that are coming in?
So it looks like the overwhelming answer so far is no, which I would also agree with. Wonderful,
thank you. That is correct. Using CalFresh does not affect your application for citizenship.
Looks like it was no. It was everybody agreed it was no.
Yay! Okay, that's great. Let's do a couple more, and then you can tell me all the other questions because I whizzed through this. John and his children. John was granted deferred action under DACA. That's deferred action for childhood arrivals. And he's young, but he has 2 kids who are both U.S. citizens and who live here. So dad has got DACA, deferred action for childhood arrivals. That's for people who came here as children and have been here at least 5 years. He lives with 2 kids who are U.S. citizens. Can the household get CalFresh? Do we think the household can get CalFresh? And if so, who? So just type it in. And either Francesca or someone else will tell me what's coming in. What's coming in?
All right, looks like 2 eligible children.
That's correct. The 2 children who are U.S. citizens are eligible. The dad with DACA, deferred action for childhood arrivals, is not eligible for CalFresh. We don't have any, we only have a limited types of immigrants who are eligible for CalFresh. People with DACA are not. John has to show his income, and his income will be prorated to his kids who are seeking the benefit.
And then just because this came up in questions earlier, I had somebody ask if a client applying through DACA would have to worry about public charge. I know you addressed this, but just to reiterate.
No, let's address it. So if you've got DACA, applying for DACA, there's no public charge issue in applying for DACA. DACA itself does not give But so if in fact they're a person with disabilities and they get CAPI, and then they have a separate pathway to lawful permanent residence through a family member, not through DACA, then it's possible that public charge could come up. That's the only thing I can think of. Let's say public charge does come up. Well, they won't get the CalFresh in the first place. But if someone did get CalFresh, let's see if we've got it here, and they were applying for permanent residence with the CalFresh count against them in a public charge determination. So new hypothetical before we get to this one. I have a green card, or I don't have my green card yet, but I've used CalFresh and I'm applying for my green card. Does the CalFresh count against me? What do people say?
All right, everybody, send in your answers via your question box. And looks like we're getting a lot of no's.
And those no's are correct. Using CalFresh does not affect your application for a green card. And so that's great. Let's do Tom and Irma.
Great.
Tom already has his green card. He's a lawful permanent resident, and he was sponsored by a relative who lives very far away. Tom lives with his wife, Irma, who is undocumented, and their U.S. citizen children. So 3 different statuses in the family. That's very common. They're low income. Can the family get CalFresh/CFAP? So let's see what we hear.
So it looks like we're getting a lot of yeses.
And what about that sponsor?
So we have 1 yes for the children and Tom, unless Tom opts out.
Okay, that's very good. And we know Irma is undocumented, so she's not eligible for the CalFresh at this point. And if Tom's sponsor is providing nothing to them and they're under 130% of poverty, they can qualify with no deeming. If they're deterred, Tom, as someone suggested, could opt out and seek benefits just for the kids. Okay? Good. Last thing here. So Irma, remember, Irma is undocumented. Let's say she's working. What does she need to disclose?
All right, the answers are pouring in. Looks like everybody says income.
That's right. She needs to find a way to disclose her actual income, but she does not need to provide a Social Security number, particularly if her Social Security number is not her own. I'm going to give you some resources that you can look at, and then I'm going to entertain questions. So the Food Stamp Agency, the USDA, through the Food and Nutrition Service, has a bunch of helpful resources on the rules for immigrants to get SNAP. So there's a SNAP non-citizen guidance. I have the link there. A public charge letter that looks official and has been updated and says, no, using SNAP will not create a public charge problem for you. A guidance by HHS and the USDA about questions that can and can't be asked on application forms. It's always worth looking at your application forms to make sure that they're okay. A helpful letter about verification of a sponsor's income, and this letter kind of came about in response to some misinformation that in a California all-county letter, and so California updated its all-county letter, revised it to clarify the rules, and the rules are that if you are claiming an exemption from deeming, if you say, hey, I'm indigent, or hey, I'm a domestic violence survivor, don't count my sponsor's income, then you are not responsible for going to get your sponsor's income. So you should have the ability up front to tell the agency whether you're exempt from deeming, and therefore you don't need to go after your sponsor to find out how much your sponsor is earning. And then there's a nice letter from USDA about proving income, and this was generated from another state where they had people who were not only working under a Social Security number that didn't match theirs, but also under a different name. And they give hints, the agency gives hints on how an applicant can provide an accurate information about his or her income and name without, and focusing only on collecting correct information from the family and not deterring them from getting the benefits for which, in most cases, it's the children would be eligible. So, helpful letter. And then we at the National Immigration Law Center also have information posted on our website that might be helpful to you all, including the immigrant eligibility rules in California, materials on public charge. We've got a question and answer piece on benefits for sponsored immigrants, especially for California. And then we have a little more information, we didn't cover it here, on survivors of trafficking, domestic violence, and other serious crimes, because there are special rules governing access to public benefits in California for this group. And with that, I'll ask what other questions there are.
Okay, thank you so much, Tanya. That was so much information, and I think those resources will be particularly helpful. We do have a lot of questions pouring in, and just a reminder for everybody, you can submit questions at any time through your question box. I'm going to start with one that was a follow-up to the last scenario we discussed. What would Tom, the immigrant that we said was a lawful permanent resident sponsored by a relative who lived far away, what would he need to present from the relative who was sponsored? Maybe we can talk about what he would need to present if he wanted to go through with deeming and what he would present in order to claim indigence.
Great. If he is claiming indigence, all he needs to do is to tell the agency that he is claiming indigence and show them the income and in-kind resources and other materials that he's receiving from the sponsor or any other source. So just like any other food stamp applicant, he would need to disclose what the actual family is actually receiving if he claims the indigence exemption. And then he would most likely need to provide the name of the sponsor so that they can report it to the USCIS policy division. And that's about it. They can also find that if they verify his status, that he has a green card. There's information in the records that they have at USCIS about sponsorship, so they could find it that way as well.
Okay.
If he goes forward with deeming, then he would be responsible, at least for working with the agency to get the income information from the sponsor.
Okay, great, thank you. And then another question regarding income. I'm sure you know, they've changed the rules in CalFresh for the gross income test to being from 130% of the federal poverty guideline to 200% of the federal poverty guideline. As far as this indigence exemption, are people that have incomes between 130 and 200% of FPL potentially eligible for CalFresh through indigence?
Oh, that's a great question. I think not, because because the indigence exemption test is still, at the federal level, is still 130% of poverty. So if they're above that, then their income alone would not qualify them for the indigence exemption. So they would be subject to deeming unless they opt out or unless they meet another exemption from deeming.
Do you know if that would change at all if would the funding be coming from CFAP? Would it have any impact on that?
Well, that's interesting. Well, the CFAP program right now, unless there's a new rule that I'm not aware of, adopts the federal deeming exemptions, except for the 3-year period. So if CFAP were to, that could be a point of advocacy for CFAP to revisit its rules.
Okay, great, thank you.
Right now,
and then I'll just do one more continuation of the Tom scenario. In Tom's scenario, what would be considered the family size and how would they calculate income? If you want to just briefly touch on that.
Well, Tom's scenario, if it's a lawful permanent resident with 2 citizen children and a wife who's undocumented, then I believe what they would do is, and we're assuming that everybody's part of the unit, part of the food stamp household. Let's just assume that for now. So the lawful permanent, this is complicated. The lawful permanent resident's income, if he's getting food stamps, they want to maximize it. So they do a 2-step process. Let me just think about this for a minute. This is SNAP. The kids are getting SNAP. If Tom's been here for 5 years, then he'd get SNAP too. And I think what they do is they count, I'm going to get this wrong. I know that for Irma, they prorate her income to the others. The family size doesn't include her. So they prorate her income, family size doesn't include her. And for Tom, I think they, if he were getting CFAP, I think they might, I think I might have to follow up on this to be sure, but I think they might not count his income in the first place, figure out what the benefit level would be in not counting his income, and compare it to what it would be like if everyone were a citizen, and cap the amount that they would receive at the amount that they would receive if everyone were citizens, and then they would put him into CFAP if he's here less than 5 years. So it's very complicated, and I don't think I may have not said it correctly, but they have special rules to try and maximize the amount of federal food stamps first, prorating the income of undocumented immigrants, and sometimes excluding the income of lawful permanent residents only to compare it to what it would be like if they were all citizens. So I'm sorry that's so complicated.
Well, that's super interesting. All right, so we have a couple more questions we're going to try to get through. We have about 8 minutes left for questions right now, and we will get to some questions after Cindy's presentation as well. So we've heard a lot of things about work quarters, and if you could just let us know how work quarters are counted. And I've also heard that work quarters don't always count if somebody received Medi-Cal. Can you speak to that?
Sure. The work quarters come from the Social Security Administration. They're the ones who kind of are in charge of it. And it's kind of interesting that they set an amount per quarter that varies from year to year. Like over time, the amount that you need to earn in order to get credit for one quarter has gone up over the years. You can earn enough in one quarter or in 1 month to get you 4 quarters. So you don't have to earn it all at different points in the year in order to get 4 quarters. You can't get more than 4 quarters of credit per year. So let's say, I don't know what the current number is, but let's say you have to earn $1,000 to get a quarter. You could earn $4,000 in January and get 4 quarters and be done for that year. And then you wait till the next January to earn your other quarters. What was the other question? So they're recorded with, they're recorded with the Social Services Administration, so you need to kind of check with them and see what's been recorded. If you don't have all your work history recorded in their database, you can work with them to kind of pull together your proofs that you worked in, other years that aren't recorded and get them recorded in the Social Security database. And for this purpose, any quarters received of work history received while you're receiving a federal benefit, whether it's federal Medicaid, federal SSI, federal SNAP, or federal CHIP, I think it is, those quarters can't count. Most people in the situation are not getting federal SSI, and they can't get federal Medicaid until they've been here for 5 years if they're a green card holder in many cases. So these rules don't always stop people from earning the quarters, but they are one more complication and wrinkle to getting credit for 40 quarters of history in the U.S. for these purposes. Good
question.
questions.
Thank you.
Yeah.
I think we have about 5 more minutes. So let's see another question. Is there any time limit on how long a sponsored immigrant or refugee can receive CalFresh benefits?
It's the same rules as citizens. So no particular time limit, no. And no immigrant-specific time limit in CalFresh.
Great, thank you. And then would you be able to speak to the 3 to 5 year period with CFAP? There were some questions around that.
Yes, it's very strange. You get your green card and you go to and you're an adult. You go to CFAP first because you're not eligible for federal SNAP, and your sponsor's income will count for 3 years. And then after the 3-year period, you have 2 years where a sponsor's income doesn't count at all. But then once you've been a green card holder for 5 years, you're eligible for federal SNAP, and your sponsor's income becomes relevant again. It's just a quirk of California and federal law together. Okay, and thank you for that. A question regarding that process that you talked about in the beginning, as far as the questions that are asked during an interview to get, I believe, the green card. Are people required to say that they've received public benefits if they've only received them for their children? So say, for example, a parent is applying for a green card and they ask if they've received public benefits, and the only benefits they've received were in the name of the children. Would that technically require them to answer yes? Well, it depends on what the application is, but in general, if somebody has not received benefits themselves, but only their children have received benefits, then no, they don't have to say that they've received the benefits, because it was the child who received the benefits, not the parent. So in general, the answer would be no. Now, if they're trying to get a green card, they may be asked about they may be asked a different question. They may be asked, have you or your children received a benefit, like CalWorks? And receiving your child's use of CalWorks, so we're now in the public charge kind of inquiry, can be relevant if you, the parent, are relying on your child's CalWorks grant as your sole means of support. So in those cases, it can be relevant. But if it's a straight-up question about have you received public benefits, then the answer is no. Okay, thank you. Is there any data around how many people apply through Indigence for CalFresh? I haven't seen it. You could ask DSS if they have the data. I haven't seen it. Okay. And then we have a multi-part question. Let me see if I can tease it out here. If the sponsor's income decreases and they can no longer support the person who they sponsored, can the immigrant apply for CalFresh? And what if the sponsor from the above scenario is a spouse? Can they both apply for CalFresh? Okay, let's try. Well, you could always apply for CalFresh, and if you're applying for it and the income is deemed, but the sponsor doesn't have any income or has very, very low income, then the family might be eligible even with deeming, because the addition of the sponsor's income doesn't put them over, especially if you're at 200% of poverty. That's something I didn't really know about, so that's great. And what was the other question? The spouse would be in the same household, so same thing for her. Yeah. Okay, great. All right, so it looks like we have hit the end of our first round of Q&A. So thank you so much, Tanya. I know those were a lot of questions. Well, and a couple of those, especially the income calculation, where I kind of struggled to get the right answer, I think it's maybe better for us to take a look at the links that I provided, and you'll get more detail about how those operate. Great. And just a reminder to everybody, you can continue to submit questions for Tanya or Cindy at any time during Cindy's presentation. Tanya has also graciously offered to follow up if there isn't enough time for all the questions that we get. So without further ado, I will introduce Cindy Lin to you all. Cindy Lin is our CalFresh Community Partnerships Coordinator here at the SF Marin Food Bank. Prior to working at the food bank, Cindy worked in the Chinese community as a family advocate for new immigrant families and victims of domestic violence. Cindy, I will let you take it away. Okay, thank you. Hi, everybody. Like Francesca says, my name is Cindy, and I am a part of the team here at the SF Marin Food Bank. Next slide, please.
So to give a little bit of context about my sort of limited experience and what I do for my day-to-day, I work primarily with Chinese families, and a majority of them are sponsored immigrants. I would say it's close to 95% of all the clients that I encounter in the community are sponsored. Some of the information that our clients have been hearing and believed to be true are things that they've heard for many, many years, things that, maybe grandma told a grandchild, or, grandma heard about it a few decades ago and then shared with the more recent immigrants. So when I'm starting the conversation to talk to them about CalFresh, about anything pertaining to sponsorship, anything pertaining to immigration, really, I tell them that things have changed. Usually at that point, I explain to them, through those changes, a lot of things have changed. Income, the resources test has changed. That's not a requirement anymore. And then I bring up, a lot of things pertaining to green card holders and those who have sponsors have changed within the county. I'm not sure about the situation in other counties, but I do know that here in San Francisco County, our EWs were recently kind of given a little bit of a refresher pertaining to sponsorship and indigence. So I let my clients know that, and usually at that time I'm able to give them a little bit more information without them just shutting me out. Next slide, please. Whenever I go out into the community, I make sure I bring materials with me, because we have a lot of people in our community who have a lot of fears pertaining to, I'm a green card holder now, I want to apply for citizenship later, what's going to affect me, what's not going to affect me. Our number one fear in our community is that they fear that when they are applying for CalFresh, they are directly taking money from their sponsors. As Tanya said before, that's not necessarily the case, and we don't really see situations really playing out like that. But a lot of my clients really, really believe it. So I give them information right off the bat so they can read about it. The little clip that I have here, the great thing about that one is that it's not only about SNAP, it also talks about WIC, it talks about healthcare programs, and I let my clients read over it. We have it in English, Spanish, and in Chinese. And then I make sure that I give them the state brochure. The state brochure for CalFresh has some information about immigration. So I want to be able to give them a lot more information than they can get elsewhere, so that I can continue to talk to them about immigration, about sponsorship. The next thing that I try to make sure to do is explain CFAP to my clients. We learned a lot from Tanya earlier, but sometimes when I talk to community members, they have no idea what CFAP is, and that's when I hear things like, Ms. Lynn, I hear that you can only have CalFresh after you've been here 5 years. I hear that you can only have CalFresh if X, Y, and Z. But that's mostly because clients are not really aware of the different programs. Certainly for clients that are receiving SNAP, whether it's from CFAP or it's from federal dollars, they don't know the difference because the program to them essentially is the same. But sometimes I do find that if I explain to them that in California there is a special program for people who've been here with a green card from 0 to 5 years, there's something different pertaining to their situation, people begin to understand a little bit more of why, oh, my friend went to apply for CalFresh during 3 to 5 years and they didn't have to do sponsored deeming. But if I haven't hit 3 years and I go in, I don't want to do that. And it's because they haven't really heard the different rules and regulations pertaining to CFAP. And then I do remind them that, even after they're not eligible for CFAP, they will reevaluate their situation after the 5th year. And, a lot of times that's when a lot of our clients decide to withdraw from the program, withdraw from SNAP, because they feel like, well, I can't have it anymore. But it's actually because they didn't know that they were going to be reevaluated, so they decide to opt themselves out at that point. Next slide, please. Indigence, as we've just heard, is an exception to a family who would otherwise have to do sponsor deeming, I would say a lot of my clients qualify for indigence because they're not receiving any support from their sponsors and they are really, really struggling. A lot of people that I see who qualify for indigence are usually people who've come to the country after they've already turned 65. So I see a lot of older grandparents who really can't find work, but they're too afraid to apply for CalFresh because they're not sure what indigence is and they're not sure about CFAP and they just don't really know much about the program. I will say that indigence is a relatively new concept to clients and even to some advocates here in San Francisco. I'm not sure too much about other counties or other agencies, but for our clients, whenever I bring up indigence, their eyes just look at me and they say, what are you talking about? Because they've never heard about it and it wasn't really offered to them, whether they went to other CBOs or to the county. And like I said earlier, here in San Francisco, our EWs had a little bit of a refresher last year. So we're hearing more talk about indigence within the county. But prior to that, I had a lot of clients come back and tell me, you know, I went to the office, I didn't want to do sponsor deeming, and the EW told me, I'm sorry, too bad, I can't approve you. And they never offered my clients indigence, but that was before. In the past year or so, I've actually had quite a few clients claim indigence and also get approved for CalFresh, which is great. But I do try to explain to our community partners as much as possible what indigence is because it's relatively new. Not that, you know, it's a new exception or anything, but because really before last year, it wasn't really talked about. When I talk to clients about it, I really drive to the point that I've had clients who claimed indigence and they were approved. Again, like I said before, the number one fear for our clients is that they're going to have to answer to the sponsor because they think that when they apply for this program, the money is coming directly out of their sponsor's pockets. While we know that's not true, clients are always, you know, they think that's true and few things can change their minds, but once I tell them that I know other people who've gotten approved for the program through that, they ease up a little bit and they ask me a little bit more questions. Can we go to the next slide, please, Stephanie? And even when I talk a lot about indigence and all the exceptions, a lot of people are still really worried about applying for CalFresh when they're a sponsored immigrant, just because there have been a lot of talk in the community, in the various communities, in the Chinese community, Spanish community, about what it really means to apply for CalFresh. So I try to tell everybody as a group, whenever I go to a pantry or go to another organization, I tell them that first, everybody's situation is different and everybody's situation changes, because a lot of clients, when they hear something from a neighbor, they think that that applies to everybody. But as advocates and people who do outreach, we know that every person's and every family situation is a little bit different and gets evaluated a little bit differently. So I make sure that I tell the clients right off the bat, you know, when you hear this, it might not pertain to you. Sometimes that helps, and then sometimes people will ask a little bit more questions about their own situation, and I feel like the people who come talk to me after presentations, they tend to be most open-minded about receiving information pertaining to their families. A lot of our clients have, like I said in the beginning of the PowerPoint, they've heard things for many years and they think that it applies to every single person. And then after that, I give my clients a lot of time to think about it, to think about CalFresh, to think about indigence if they qualify for indigence. And then I contact them again. I make sure that I contact them again because I know that even though I gave them the information, gave them the materials, they're still feeling a little bit unsure about it. Particularly to my Chinese-speaking clients, I sometimes have to contact them maybe 2 or 3 times. Every time that I call them or, you know, see them again, they will ask me more and more questions about it. And a lot of the times, those are the clients who are in very difficult situations, maybe really, really struggling financially. And they're really, really thinking hard about whether or not to claim indigence, whether or not they're going to ask their sponsors for additional information. At that point, I try my best to explain to them the benefits of CalFresh. A lot of times, newer immigrants, they're not really sure what CalFresh is. For them, it's something completely new. It's something that they've heard about once or twice through a friend or through family members, but they don't know too much about it. So I really try to explain to them exactly what CalFresh is and what it could do for their family's food budget. And like I said before, I really try to share some testimony about other clients that I've helped or served. Usually when I talk to a client in the community, they're really, really apprehensive to any new information, especially pertaining to anything that could be deemed as a public charge. While we know that, CalFresh is not a public charge, clients don't necessarily receive that information. So I try to give them as many examples as I can. I know a family, they were a family of 4, one was undocumented, the other one was on LPR of 6 years, and then this happened, they were approved. I try to give as many examples as I can, just because clients are feeling really, really apprehensive about the program and about, sponsorship and about indigence. So those are some of the things that I try to do when I'm working within the LPR community. Of course, I know that everybody's got a little bit different of a strategy to go about it, but those are some of my strategies. And if you have any questions for me, I would love to answer them. If you want to ask me through email, I think my email is at the beginning of this PowerPoint. Yeah, thank you.
Thank you so much, Cindy. It's wonderful to have your perspective. I know you've worked a lot with sponsored immigrants. So we're going to get into some final questions. And just a reminder, if you do have any more questions, now is definitely the time to submit them through your question box. All right, so we had one question that came up a little bit earlier, and it's something I was surprised to see, and I wanted to bring it up to Tanya to see how you would advise this person. She had been told by her county that parents should not opt out of the home, otherwise that children who are legal permanent residents would not be eligible for benefits. She said the county staff use the quote-unquote all or nothing rule.
Eligible immigrant, kind of like an undocumented immigrant, for purposes of, they wouldn't get benefits themselves, their income would be prorated to the rest of the household members, and the family size would be smaller. So, it could be that the way the math works for this case makes it harder for them to qualify, I don't know, but there's absolutely the right to opt out in seeking benefits for any member of the family.
Great,
CalFresh.
Thank you.
Mm-hmm.
Thank you.
CalWorks is different. CalWorks is different. I got this question from someone where there was a family seeking both, and I just want to caveat that in CalWorks they have something called a mandatory assistance unit, so you can't opt out in the same way. Okay?
Okay, great. Thank you. And then somebody asked if it would be possible to define indigence one more time for everybody.
Sure, and let me just go to the slides. I mean, basically it is, hold on, I'm going to go to my slide on it. It's a federal definition, and it says that if the household income plus any contributions, including in-kind assistance altogether, is under 130% of the federal poverty level for that family, then the family is considered indigent for this purpose and not subject to sponsor deeming.
Great. Thank you. And then, practically speaking, how would you recommend that people that are helping people through the CalFresh application process, indicate that people are claiming indigence on the CalFresh application?
Well, you know, maybe Cindy has more experience with the application itself. I think they could certainly just submit their income information and tell are they doing it in person or are they doing it electronically?
Yeah, Cindy, I think if you want to speak to this, that'd probably be helpful.
Sure. So through my experience, the most helpful thing for any family or individual to claim indigence is to write a statement. Some of our contacts at the county has actually advised that unless you write that statement, maybe just looking through your income, it's not going to be obvious that you're claiming indigence. So I always tell my clients, whenever you want to apply for indigence, and I tell all the sisters that we work with as well, whenever you have someone come through the door and you think they're going to apply through indigence, always help them write a statement. And that statement can be pretty simple. You know, something like, you know, my name is Cindy. I would like to apply for CalFresh through Indigence because of, you know, whatever the reason. And then I make sure to tell the client to sign and date that statement and send it in with the rest of their documentation. I also tell my sisters that when clients need help writing that statement, they can help the client write that statement as long as the client is the one that's signing and they understand what is being written. It's very, very, very helpful to have that statement of indigence.
Great, thank you, Cindy.
That's helpful to know. It might make sense to advocate for having a form, though.
Yeah, absolutely. I think sometimes the county will mail back a form for the clients. It's just the empty affidavit form, the self-verifications and stuff like that. They sometimes send our clients a blank form, and all it has is just like the county logo on it, and they ask our clients to write the same statement twice, which I think is a little bit of a barrier to many of our clients. So if there was a form for that, I think it would be really, really helpful. And you can create a form for that within your agency.
Great, thank you, Cindy. So just a couple more questions. How do we know, so as people that are helping through the application process again, is there anything that an assister would have to do if their client is applying for CalFresh through CFAP? Is there anything that they have to note on the application? Or, you know, do you have anything else that you'd like to say as far as that goes?
Cindy, you can answer, but it should be seamless from the point of view of the applicant.
Yeah, usually for CFAP, we don't have to indicate anything else. It's really for indigence.
Okay, great. And then a follow-up question to the question we asked earlier about the Federal Poverty Guideline and indigence. If the applicant is between 130 and 200% of the Federal Poverty Guideline, but the sponsor is not cooperating for deeming, Tanya, do you believe that they'd be able to meet indigence requirements? And maybe if that's too much to take on right now, maybe we could follow up about that one.
Yeah, I mean, I think if their income, including any contributions, is over 130% of FPL, then indigence won't be available to them. So,
okay.
And then they are responsible for getting information from their sponsor, and that sounds like that's a barrier in some cases.
Okay, and then
you know,
another question.
Once more, unless they meet a different exemption from deeming. But go ahead.
So if the sponsor refuses to cooperate with sponsor deeming and the client is between 130 to 200% of the FPL, would that put them into another category as an exemption and therefore claim indigence because sponsor is not cooperating?
There's no exception in this program for sponsors who don't cooperate. So it's a problem, yeah.
Thank you.
Mm.
And then this is something I've never heard of. It says, is there an S visa, snitch visa, for those who helped the U.S. government on drug bust available? Is the county assisting those people on S visas?
Okay, there is an S visa, and it's you know, and some people do call it a snitch visa, and it's available for people who cooperate in prosecuting certain crimes, but it doesn't. It makes you a non-immigrant, but it doesn't make you eligible for CalFresh.
Great, thank you. And then unless anybody has any final questions, I think we may be ready to wrap up. So I'll give you guys one more minute to submit questions. Again, the webinar will be posted along with Cindy's PowerPoint and Tanya's PowerPoint on the CIFB website. I believe you all will get a follow-up email as well. And I think that concludes our webinar. So thank you guys so much for listening. That was an amazing presentation from both of you guys. Thank you so much, Tanya Broder from the National Immigration Law Center and Cindy Lin from the SS Brand Food Bank. And we'll see you at the next webinar. Thank you.
Thanks very much.